unqualified to moderate this. However, I share the concern of lawyers for nuclear abolition since about 40 years. Nuclear weapons and the law on human rights and future generations. As nuclear tensions increase, dangerous times have raised legally loaded questions about nuclear weapons. Should the US violate or undermine the Iran nuclear deal? Even though the geopolitical situation on the Korean Peninsula has improved recently, would the US president have the power to launch a nuclear strike against North Korea in case Kim Jong-un would be unwilling to relinquish his nuclear weapons? What is the legal status of the Trump administration intention, telegraphed in the recent nuclear posture review, to expand US nuclear capabilities and arsenals when the NPT supposedly commits everybody to cut and eventually eliminate nuclear weapons? But there is also a broader legal dilemma looming over production, testing and threat of nuclear weapons, how they affect the human rights of future generations. Those threats to the future are also compounded by nuclear energy, which generates radioactive waste, which we are manifestly unable to control, and by destabilizing the climate that has enabled and sustained human civilization. Can such crimes against the future be legal? How can we respect the human rights of future generations in view of them? Recent international symposia studied those questions, and the conference in Basel produced a declaration on human rights and transgenerational crimes resulting from nuclear weapons and nuclear energy. This is available on the desk in the back. Protecting future generations from the threat of nuclear weapons was an important consideration in the International Court of Justice 1996 affirmation that threat or use of nuclear weapons is illegal, given their long-term and indiscriminate impact. But despite the court's decision, most nuclear-armed states retain illegal policies to use nuclear weapons, including in a first preemptive strike. In general, current law fails to safeguard the rights of future generations, but that doesn't make failure defensible, sustainable, or in accord with legal principles. Evolution of this area of law is necessary and inevitable. The 2000 nuclear weapons, which were detonated for testing since 1945, released millions of curies of radiation and impacted human health globally, and will do so for generations to come. Most nuclear testing victims live in remote areas like the Pacific Islands, the Kazakhstan steppe, or the North African Sahara. They have largely been forgotten. Today's younger generations are unaware of their sacrifice. Yet forgetting is perilous, because today's youth will be tomorrow's victims unless the cycle is broken. There are some legal efforts to break it. For example, the treaty for the on the prohibition of nuclear weapons, signed by 122 nations last summer, obligates signatories to provide environmental remediation and assistance for nuclear test victims. But the provision is unenforceable because none of the 9 nuclear weapon states signed the treaty so far. Like nuclear weapons, nuclear energy also poses enduring threats to human health. The Chernobyl explosion caused widespread contamination across the region and the whole Europe. High volumes of radioactively contaminated water from Fukushima continue to leak into the Pacific. These too are crimes against the future. Some isotopes in nuclear waste have half-lives of thousands of years. Waste repositories will need to be guarded for unimaginable time periods, with associated financial, logistical and security implications for future societies. This is an enormous burden we leave to our descendants. Like the TPNW, the International Covenant on Economic, Social and Cultural Rights, ICESCR, asserts the human right to health, applicable to nuclear contamination. But in practice, that right isn't respected. For example, Japan ratified the covenant and the Japanese constitution even defends the transgenerational principle on human rights in Articles 11 and 97. But despite those legal principles being articulated, the Japanese media is still prevented from reporting on current events in Fukushima, and medical research on the effects of the meltdown is still restricted. The Japanese government maintains that small amounts of radiation are harmless, so limits for public radiation exposure could be increased from 1 to 20 millisieverts per year, the same as for radiation workers and small children. That's unconscionable and untenable, not to mention discrimination against young women and children who are much more susceptible to radiation exposure than men, with higher risks of cancer and non-cancerous diseases. Radiation exposure may present mutations and diseases in their offspring decades later. Japan's handling of the Fukushima disaster fails to accord with its own constitution as well as the ICESCR. Failing to combat climate change effectively is also a crime against the future. The chances of meeting the Paris goal of limiting global warming to 2 degrees Celsius are receding since the US withdrew, and financial contributions of many signatories remain out of scale with the problem. Greenhouse gas emissions have risen in the 2 years since the Paris Accord. If we stay on this too little, too late trajectory, will not only fail to protect the human rights, but much of life on Earth. Today we will hear from 3 experts who deal with human rights issues in the context of transgenerational impact of nuclear war, nuclear catastrophes and climate change. These must be seriously considered now, and they require a paradigm shift of legal thinking about framework to realities of nuclear threats and climate change. But those changes are vital to protecting the human rights of future generations. And 2 members of this very future generations will respond to the presentations after the talks. First speaker is Emily Gaillard. She's an associate professor of law and research at the University of Caen in the Normandy, France. She's a member of the pôle risque, qualité et environnement durable à Maison de la Recherche et des Sciences de l'Homme. For her thesis entitled Future Generations and Private Law Towards a Law for Future Generations, she has been awarded the prize by the French Academy of Political and Moral Sciences. Congratulations. In 2010, that was. Her works highlight the emergence of a new temporal paradigm which renews the legal framework but also initiates a new legal logic. She strives for a revitalized juridical humanism which respects the post-humankind through time and space and all the livings and supporting conditions for life. The topic of her talk is human rights for future generations at the nuclear age. Please, Emily.
Thank you very much. So, hello to everybody. I'm very pleased to be here today as an academic. I'm going to explain to you what is law for future generations. So it will be this, the first part of my presentation to be wider than nuclear threats. So the very first time we have visualized our Earth, we realized that we were sharing a small planet and the same planet. So spontaneously, the effect of visualizing this photography is that spontaneously at the world scale, an ecological consciousness has arisen. So since the 70s, 80s, we can see that there has been a paradigm shift that I'm going to explain to you, slide 3. We definitely entered into a new legal era, which I call the transgenerational era. We can find some very interesting developments in Hans Jonas' books, who is a philosopher. He explains that we have no ethical rules in our classical theory to think about our responsibility for future generations. Now we have geologists who are more and more using the word Anthropocene. It's not a word to explain that humankind has now the possibility to disturb geophysic equilibrium on Earth. Humankind has become by itself a geophysic force. So, what about the law? My work as an academic is to accompany this paradigm shift in order to make law a new tool to protect future generations. First of all, I would plead for the recognition of two foundational principles, which I defended in my thesis, in order to institute future generations in law. First of all, the principle of temporal non-discrimination. What does it mean? Traditionally, law is made for the present generation. The future will be for the future law. But now that we are putting into danger future generations, we have now to make this paradigm shift. And this principle of temporal non-discrimination means that it is no more of any value to say that because future generations do not exist, they do not need to be protected by the law. Now, the idea is the following. If you put future generations into danger now, it becomes from a democratic point of view a necessity to protect them. And you can have various principles such as if you know with certainty that you're putting them into danger, then it can become crimes against future generations. If it's in a context of uncertainty, then you have to mobilize the precautionary principle. Second founding principle is the principle of dignity of future generations. This is really important to realize that future generations need to be protected, and if you recognize the principle of dignity of future generations, then you can plead for transgenerational human rights. Slide 3. So what is paradigm shift about? We can plead for the recognition of transgenerational human rights, and that is already occurring if you are aware of climate change mitigation, for instance. But let me explain first what it is. So traditionally we teach that there are various generations of human rights. The first one, for instance, is, I can take the right to life. The right to life traditionally means that you have the right not to be threatened, to be condemned to death penalty. But for future generations, what does it mean? It means the right for future generations to be born without any contamination, for instance, without transgenerational genetic damages. The right to the freedom to come and go is another human right from the first generation. So there is no more freedom to come and go in Fukushima or in some places where nuclear disasters has already occurred. So this is an infringement of rights of future generations. From the second generations of human rights, we are used to talk about right to health. But actually, right to health for future generations is a wide right to health. For instance, I also work on the topic of pesticides. You know, residues of pesticides get linked to our genome. So this is also a transgenerational threat. So if we do not work for this recognition of transgenerational human rights, at the end, there will be no more human rights for future generations. The third generation of human rights is traditionally, for instance, I just take one example, is the right to a healthy environment. Today, most of our constitutions throughout the world recognize the right to a healthy environment. We have climate change mitigation now occurring throughout the world. So we can see that now, from an international point of view, we have something really strong occurring now. This transgenerational way to highlight human rights is a reality which is occurring now. The fourth generations, which I work also for, is out of our topic, but I would like to mention it today, would be the right to a protected humankind condition. This can sound a little bit philosophical, but now I I just want to alarm on the fact that there is an ideology which is called singularity and transhumanism, and they want to enhance man. So this human rights needs also to be occurred. So from my presentation, next slide, I would like to strengthen in two main ideas. First of all, that there is a strong convergence of change of ways of thinking in international law, which tends to protect future generations too. In international, environmental, and human rights law, there is a convergence on that way. And second idea is the following: even for those who are reluctant to adopt national law protecting future generations, it is impossible to deny the existence of international customary law which protects the environment and future generations. So more and more people with whom I work wants to ask advisory opinion to the ICG on the obligation of states on about climate change, but we should also think about it on the nuclear fields. Now, next slide. I would like now to strengthen on our topic, that is nuclear weapons. I was hearing this morning all the delegation were talking about this famous Article 4 concerning the right to peaceful use of nuclear energy. I shall emphasize on the fact that we inherited of a myth. Günther Anders, a famous philosopher, said that there is no fundamental difference between peaceful use and military use of nuclear energy. This is really important because there is no distinction from a scientific point of view and from the risk that we are creating for future generations. This is absolutely obvious. So we are creating transgenerational environmental and health pollutions. You know that it damages the genetic of future generations, but not only of humans, of all the livings. We need, I call for a transgenerational political and legal matrix. We need to renew our political frames and to recognize this transgenerational democracy. And this transgenerational democracy is strongly interlinked with the rights of nature. So, I would like to emphasize on this idea that future generations have the right to benefit human rights. They have the right to have the horizons of future remain opened. And nuclear technologies, we have to be aware of that. This technology closes the horizons of future. The future has no more future. And in Fukushima, in Chernobyl, in that places, we know and we live what is a disaster. Next slide, I'm almost finished. The second idea, if you recognize human rights for future generations on the one hand, on the other hand, you can perfectly recognize crimes against future generations. We have already recognized crimes against humankind. This already exists. So, if we plead for an obligation, a legal imperative to protect the survival of humankind through time and space, this concept of crimes against future generations becomes real and very important. And this legal imperative is not an anthropocentric concept. It is a legal imperative which is related to the protection of the environment and to all elements which sustain life. So the reality, the real intangible rights is not the right to create, to develop, to make research in nuclear fields for peaceful goals. The reality is that the intangible human rights of future generations is the right to breathe clean air, the right to food, and the right to live and to be born without genetic and transgenerational threats or damages. Hope I introduced you clearly to the law for future generations. I'm very happy to be here and available to answer to all of your questions. Thank you for your attention.
May I ask you to write down your questions? We will discuss at the end of the 3 talks and the contributions from our young members here. As the next speaker, I'd like to introduce Dr. Daniel Rietiger. He's a senior lawyer at the European Court on Human Rights in Strasbourg, and he teaches international law and human rights at Suffolk University Law School in Boston and at the University in Lausanne in Switzerland. He has published very interesting books: Humanization of Arms Control, Paving the Way for a World Free of Nuclear Weapons. Daniel is also the founder of the Swiss affiliate of IALANA, in case not everybody knows this very important. Daniel, please.
Thank you very much, dear Andy, ladies and gentlemen, dear friends and colleagues. Thank you for giving me the floor. The aim of my intervention is to analyze and stress the relevance of human rights law for the protection of the individual in the nuclear age. Considering the limited time that I have at my disposal, I won't be able to go into all the legal details. More details on the topic you can find, as Andy introduced, in my book that I published last year. The relevance of human rights to nuclear weapons has very recently been acknowledged officially, namely through the adoption of the new Treaty on the Prohibition of Nuclear Weapons in New York on 7th July 2017. Indeed, on several paragraphs, this treaty refers explicitly to human rights. First of all, in its preamble, where it states that the states parties to this treaty reaffirming the need for all states at all times to comply with applicable international law, including international humanitarian law and international human rights law. Moreover, in its Article 6 on victim assistance and environmental remediation, it states, each state party shall, with respect to individuals under its jurisdiction who are affected by the use or testing of nuclear weapons, in accordance with applicable international humanitarian and human rights law, adequately provide age and gender-sensitive assistance without discrimination, including medical care, rehabilitation and psychological support, as well as provide for their social and economic inclusion. It's clearly human rights language everywhere. Apart from those explicit references to human rights law, there are many other uses of language, such as victims of nuclear weapons, including Ibakusha, that are closely linked to human rights violations. In brief, the new treaty prohibiting nuclear weapons confirms the close link between human rights law, nuclear weapons, and related activities, for instance, testing. In my short presentation, I will address 3 points. First, the advantages of human rights law, and second, the most relevant human rights in terms of nuclear activities, including its relevance to so-called vulnerable groups, and third, we'll do some reflection on litigation and campaigning in human rights fora. So the first point, the added value of human rights law in the nuclear age. What is the relevance of human rights and what makes it worth being analyzed in the nuclear field? First of all, it is applicable in all circumstances, contrary inter alia to international humanitarian law that only applies in times of armed conflict. So we lawyers don't have to ask ourselves, is the threshold of an armed conflict reached or not? Second, while human rights treaties have traditionally been thought to protect the individual against arbitrary interference by the states into his or her rights, a more recent trend, based on a dynamic interpretation of human rights, imposed on states the duty to take so-called positive measures in order to protect and promote human rights. For instance, the duty to protect against terrorism, duty to protect human rights against population after a nuclear accident or nuclear attack. These are issues which would be important in the nuclear field. Third, maybe the most significant advantage of human rights law lies in its institutional dimension. Victims of human rights violations, including victims of a potential nuclear weapons use, can rely on treaty bodies and mechanisms providing legal remedies. This institutional aspect distinguishes human rights law from other branches of international law, in particular international humanitarian law, which relies largely on the goodwill of the state parties, the good faith of state parties, for implementing its rules and principles. Fourth, the particular
particular nature of certain human rights has to be stressed. Certain fundamental rules of human rights, though, have to date attained customary law status and therefore apply also to states that have not ratified relevant human rights treaties. It is generally acknowledged that this is the case with the rights guaranteed in the Universal Declaration of Human Rights of 48. Moreover, the normative supremacy of certain norms of international law has to be stressed too. They are called peremptory norms of international law, so-called norms of use covenants. No derogation from such a rule is authorized, never under any circumstances. From my point of view, this debate is relevant for the use of nuclear weapons, in particular since I defended in my book that such use is likely to affect human rights that have a use covenant nature, in particular the right to life, the prohibition of inhuman or degrading treatment. Fifth, there is also recognition in international human rights law of certain groups of victims that are particularly vulnerable. For instance, indigenous peoples, women and children. Certain instruments, treaties as well as non-binding declarations have been adopted specifically for their protection, such as the UN Convention on the Rights of the Child, the UN Convention on the Rights of Persons with Disabilities, or the UN Declaration on the Rights of Indigenous Peoples, 2007. Second point, the most relevant human rights for nuclear activities. The right to life. The most obvious human rights we're talking about use of nuclear weapons is the right to life. The ICJ, in its 96 advisory opinion on the legality of use and threat of nuclear weapons, confirmed the applicability of the right to life in time of armed conflict, and moreover observed that the test of what is an arbitrary deprivation of life has to be determined in light of international law governing armed conflict, in particular humanitarian law. It is interesting to highlight that the UN Human Rights Committee, the body implementing the International Covenant on Civil, Political Rights, issued already two so-called general comments on the right to life. Those general comments are basically summaries of the practice adopted by the committee in a certain domain. Regarding the right to life, it adopted its general comments number 6 already in 1982, and more relevant, with general comment number 14 in 84, where it held as follows. It is evident that designing, testing, manufacture, possessing, and deployment of nuclear weapons are among the greatest threats to the right to life which confront mankind today. This threat is compounded by the danger that actual use of such weapons may be brought about not only in the event of war, but even through human and mechanical error or failure. Interestingly, the Human Rights Committee has started its considerations of a new general comment number 36 on the right to life some years ago. For the time being, a second draft has been adopted for further consideration. Compared to the first draft, this draft contains quite a comprehensive and useful satisfactory paragraph on nuclear weapons, which I'm not going to read out now, and this text is not yet final. But the right to life is not the only civil rights relevant in the field. I've already mentioned the special nature of certain rights. For instance, the special nature of the right, or rather prohibition, of inhuman and degrading treatment. In my book, I argue that the use of nuclear weapons could amount at least to so-called degrading treatment, since it deprives the victims of their basic dignity. It is appropriate, from my point of view, to assess the more global consequences in light of economic, social, and cultural rights, as already mentioned. In the book, I examine the relevance of the following rights in case of use of nuclear weapons: the right to development and the right not to be discriminated against, rights to the highest standard of health, called the right to health, and to a healthy environment, has also been mentioned. The right to health is recognized in numerous international and regional instruments, but the most comprehensive provision is contained in Article 12, paragraph 1 of the International Covenant on Economic, Social, and Cultural Rights. In its general comment number 14 on the right to the highest attainable standard of health, 2000, the Committee for Economic, Social, and Cultural Rights observed that, I quote, states should refrain from unlawful
polluting air, water and soil, e.g. from using or testing nuclear weapons, if such testing results in the release of substances harmful to human health. The right to an adequate standard of living, in particular the right to food and to water. The right to an adequate standard of living, including the right to food and to water, is recognized in several international instruments. Article 11, paragraph 1 of the International Covenant on Economic, Social and Cultural Rights contains the most comprehensive provision. In its general comment number 14 on the right to water, 2002, the Committee on Economic, Social and Cultural Rights noted that the right to water, even if not mentioned explicitly in Article 11, paragraph 1, falls within this ambit, in particular because water constitutes one of the most fundamental elements of human survival. The African Commission of Human Rights and Human and People's Rights link the right of access to sources of water inter alia to the right to development. The European Court of Human Rights has also significantly contributed to the emergence of a right to water, namely under the label of the right to respect for private and family life and home, in particular as regards the contamination of groundwater. Why is this all relevant in the nuclear field? Regarding water contamination by nuclear weapons, General Comment number 15, mentioned already, states explicitly that the obligation to respect the right to water includes the provision of diminishing and polluting water, for example through the use or testing of weapons. In a nuclear explosion, radioactivity penetrates the atmosphere in soil and water. In the desert of Nevada, where clean water is always scarce, US underground nuclear testing conducted between 1951 and 1992 is estimated to have contaminated more than 6 trillion liters of groundwater. To sum up, I conclude that economic, social and cultural rights, but also the jurisprudence of international courts in the field of environmental harm and the rights to private and family life at home are very relevant in the field of nuclear activities and should be considered for future proceedings by the victims' lawyers. Maybe for time reason, I skip the part of particular vulnerable groups, which I expanded in my book, especially on indigenous peoples, women, and children. I go to the last point, where I rather raise questions than I reply to them, just in terms of campaigning and litigating, and that's why we're all here to try to find ways to get rid of nuclear weapons. I found interesting to do the following remarks. What can civil society do, and how can human rights law be used by a civil society and by states, of course, as well. First, I mentioned already Article 6 of the bench treaty, the Treaty Prohibiting Nuclear Weapons, on victim assistance, that includes actual and past as well as future victims of use or testing of nuclear weapons. So it's important all victims of use or testing of nuclear weapons are protected. The future, of course, will show how effective this course will be. Second, the right to life. I mentioned that the Human Rights Committee is currently drafting a new general comment on the right to life. Our young organization, these lawyers for nuclear disarmament, together with the Lawyers Committee for Nuclear Policy in the US, have submitted several sets of submissions proposing the inclusion of nuclear weapons in this new document. As I said, the last draft, which I saw, looks quite satisfactory. Third, Human Rights Council. This is another human rights institution. Civil society is actually about to bring the new treaty, the Benn Treaty, into a periodic report system of the Human Rights Council. Each state, you might know, is being reported on a regular basis by the Human Rights Council. NGO tries to encourage the ratification by the new treaty by the states within this human rights mechanism. What other human rights forums can be thought of when we talk about nuclear issues? There are actually quite many. Talking about economic, social, and cultural rights, as I did, there's a committee on economic, social, and cultural rights implementing this treaty, which has a control mechanism and which could be used by civil
society to get human rights issues in the debate. Talking about vulnerable groups, people, which I've noted down, women, we know that there's the CEDAW, the Convention on the Elimination of All Forms of Discrimination Against Women, which is also backed up by a body, by a committee, where civil society is bringing violations of human rights by nuclear issues by this particular vulnerable group. When we talk about children, there's a UN Convention on the Rights of the Child, also implemented and backed up by a committee. Indigenous peoples, there is a secretariat of the so-called permanent forum on indigenous issues that was established in 2002. There also, I haven't tried it, but it might be useful to think about trying this forum to bring in nuclear issues. In sum, for many human rights issues, violations, groups, of vulnerable groups, of people, there exists permanent mechanisms where nuclear issues could be brought up, at least in regular state reporting systems, or even in individual complaint mechanisms, or in the framework, again, of drafting of general comments like the rights to life. Thank you very much for your attention. Thank you, Daniel. Dr. John Burroughs unfortunately was prevented from joining us today, and I introduce to you Alan Ware, the director of the Basel Peace Office, who will read a few remarks by John Burroughs. Alan is a consultant for the International Association of Lawyers Against Nuclear Arms, and the lead prosecutor of the People's Tribunal on Nuclear Weapons and Human Civilization, and the former executive director of the Lawyers Committee on Nuclear Policy. Alan, please.
Thank you very much, and Dr. Burroughs gives us apologies that he's unable to be with us today. He has prepared written comments which are available on the information desk, and I'll present those comments. The presentation Dr. Burroughs provided was primarily on customary international law, which is applicable to all states, regardless of whether they join the Treaty on the Prohibition of Nuclear Weapons or not. There's a concentration on international humanitarian law, and Dr. Burroughs picks up on these aspects, in particular the preamble of the Treaty on the Prohibition of Nuclear Weapons. So international humanitarian law, for example, is a preamble in paragraph 10, which says that any use of nuclear weapons will be contrary to the rules of international law applicable in armed conflict, in particular principles and rules of international humanitarian law. This body of law, international humanitarian law, requires that the use of violence in wartime has to be necessary, proportionate, and discriminate. Effects on both civilian populations and natural environment are part of that assessment. They are protected under international humanitarian law. Then Dr. Burroughs looks at current policies in violation of this, in particular the US Nuclear Posture Review, which claims that the conduct of their nuclear operations would adhere to these requirements. But in actual fact, that's not possible, as nuclear weapons cannot be used in compliance with the requirement of discrimination because their massive and uncontrollable effects, blast, heat, short and long-term radiation, and in urban areas, the firestorms, make it impossible for that use to distinguish between military targets and civilian populations and infrastructure which is protected. Indeed, arguing that the use of nuclear weapons would violate international humanitarian law understates this matter. So that's where this preamble provision in the Treaty on the Prohibition of Nuclear Weapons is very relevant. This provision first considers that the use of nuclear weapons would violate international humanitarian law, and then goes further and says that it would also be abhorrent to the principles of humanity and the dictates of public conscience. So this goes beyond just the basics of international humanitarian law. These principles of humanity and the dictates of public conscience are factors with legal as well as moral value. They were referred to in the Martens Clause, which is part of the Geneva and the Hague Conventions. As the nuclear ban treaty's reference to principles of humanity suggests, In many circumstances, certainly in attacks on cities, the use of nuclear weapons would constitute not only violations of international humanitarian law, but also crimes against humanity. And these crimes against humanity have been most recently defined in the Rome Statute of the International Criminal Court. The Rome Statute defines crimes against humanity as acts which are committed as part of a widespread or systematic attack directed against any civilian population with knowledge of the effects of that attack, including murder, extermination, and it reads on other impacts on the civilian population. And so the use of nuclear weapons would clearly come under that category of crimes against humanity, even though the use of nuclear weapons is not specifically mentioned in the Rome Statute. Although there is a proposal by Mexico to add a specific reference to the criminality of the use of nuclear weapons in the Rome Statute. And we'll see how far that progresses now that the Treaty on Prohibition of Nuclear Weapons has been adopted. Crimes against humanity, like human rights, can be committed in both peacetime and wartime. So they're about the sanctity of the human person, anywhere, anytime. Dr. Burrows then talks a bit about human rights, but Daniel's already mentioned a lot about that, including the general comment on the Human Rights Committee, which is in progress. What I'll just add to it is the statement that Dr. Retiger and Dr. Burrows presented to the Human Rights Committee, and that is that ILANA, the International Association of Boys Against Nuclear Arms, and the Swiss Association of Boys for Nuclear Disarmament are of the opinion that the threat or use of nuclear weapons massively violates the right to life in ways not reducible to law intended to govern the conduct of warfare. The catastrophic consequences of use of nuclear weapons vastly exceed the ordinary bounds of armed conflict and adversely impact populations in third-party states, the natural environment necessary to sustain life, and future generations. The use and threatened use of nuclear weapons also violates international humanitarian rights law, most centrally the right to life. So it's therefore appropriate that the preamble to the Treaty of the Prohibition of Nuclear Weapons, adopted last year on 7th of July, invokes human rights law as well as this international humanitarian law. So this gives some indication of the possibility of taking these principles further in the Human Rights Committee, the new general comment, than it has been in the past, and the contribution that customary law and also the Treaty on the Prohibition of Nuclear Weapons can make to this. Thank you.
Thank you, Alan. I now give the word to Marsan Nursan from Kazakhstan. Some of us in here are the future generations of our parents, and Marsan is a real future generation, and she will respond to the talks.
Thank you, Andy. So first of all, I would like to introduce my organization. It's called Abolition 2000 Youth Network, and I'm serving as a convener. So the Youth Network is a part of Abolition 2000, which is a global network for elimination of nuclear weapons. And the Youth Network is providing a platform for young people to network, to share their ideas in regards to the issues of peace, security, sustainable development goals, and in particular nuclear abolition and nuclear disarmament. We have members from all around the world, and our network is inviting young people to join to work together. So now I would like to give a bit of informational background about my homeland, Kazakhstan, because some of the panelists already mentioned about the accidents in Chernobyl, in Fukushima. Daniel also touched upon the victims of nuclear testing. So therefore I would like also to make some short input about Kazakhstan. My homeland was a part of the USSR, and during the period of 40 years from 1949 till 1989, Kazakhstan experienced 500 nuclear tests, which were conducted underground and above the ground. And this was made in the eastern part of Kazakhstan at the Semipalatinsk nuclear test site, which is also known as semi-polygon. And the residents of this area has been already affected by the environmental consequences, by the humanitarian consequences, but also social economic consequences. And the number of those people affected is 2 million people, but it doesn't mean that the impact stopped, because we know about the transgenerational impact, which is continuing and will continue for many generations to come. And as you know, my homeland is having this tragic history, and many people are still suffering from the health conditions that they are having, from the high level of radiation and cancer, and also genetic deformations, which Emily was referring to. And as a young person coming from Kazakhstan, I think it's my also personal responsibility to take the lead, that no more tests will be conducted, that no more people would be suffering, but rather we will be working together to find solutions to help those people, whether in the legal terms, whether in the medical support, or whether socially and economically, or whether thanks to the global cooperation. I know that there are also some people present from Japan, so I also would like to welcome them here. And I also think that I am probably a future generation, but nevertheless I think that I am a present generation. So therefore I would like to make a point that we should consider the rights not only of future generations, but also present, and like I would like to stress, the present generations' rights to live in the world free of nuclear weapons. And therefore this can be done in a cooperative way. And as a Abolition 2000 Youth Network convener, last year we had organized International Youth Conference for Nuclear Abolition, and we have released the youth appeal here. I'm not sure if some of the copies are available at the information desk, but if you are interested, I can share it with you. So in our youth appeal, we have highlighted the importance of intergenerational cooperation, so that we as young people should work together with the seniors who have more expertise, knowledge, and experience, so that they can share it with us, that they can transfer it to us, and we will be able to work and probably achieve nuclear disarmament and nuclear abolition in our present time. And as a last point, I would like to just make one of the recommendations. Speaking on behalf of the network, we think that it's necessary to work with young people, young professionals, young lawyers, and try to engage them and involved in the topic of human rights and human rights of future generations. And I would recommend, if any of your friends or you are working in this field, to join, for example, Yalana, and we can increase the number of young people participating, taking actions, and yeah, so that's it. Thank you.
Thank you, Marsan. We have another contribution from Japan. This is Mori. Can you come to, or will you speak from there? Please go ahead.
Hello everyone. I'm Kazue Mori. I'm a member of JANA, Japan Association of Lawyers Against Nuclear Arms. JANA is a lawyers organization whose purpose are abolition of nuclear weapons and support for the Hibakusha, atomic bomb survivors. The reason why we must abolish nuclear weapons is their illegality and inhumanity. As lawyers of the only country that actually suffered wartime atomic bombings, we must demonstrate their illegality and inhumanity in order to establish a nuclear weapon-free world. Let's do our best in order to establish a nuclear weapon-free world. Thank you.
questions, I would like to give Emily once more the word. She will read the text.
I would like to quote two articles of the Japanese Constitution because you have opened the way for what we're talking about today. So, Article 11. The people shall not be prevented from enjoying any of the fundamental human rights. These fundamental human rights guaranteed to the people by this Constitution shall be conferred upon the people of these and future generations as eternal and inviolate rights. Article 97, under Chapter 10, entitled Supreme Rule. The fundamental human rights by this Constitution guaranteed to the people of Japan are fruits of the age-old struggle of man to be free. They have survived the many exacting tests for durability and are conferred upon these and future generations in trust to be held for all time inviolate. May these two articles inspire us to propose a new way of thinking human rights for future generations.
Thank you, Emily. I now open the floor for questions. Please.
I've got a John Howland People for Nuclear Disarmament, and Alan and Emily may notice the voice of Professor Peter King in the scenario which I'm about to read out, which illustrates the weight of arguments about future generations. Basically, I want you to consider two, both almost equally terrible scenarios, but nonetheless distinct. In one scenario, a nuclear war occurs and 5%, or it might be 1%, it doesn't matter, the exact numbers don't matter, of the human population still manages to reproduce itself, and after millennia or tens of millennia, some sort of civilization, perhaps medieval, is re-established. In the other scenario, this doesn't happen, and there are no future generations. And the question is, what is the moral difference between the two scenarios? And the answer to that question is that the moral difference is almost infinite, because in one scenario, all human possibilities are foreclosed. Now, Professor King didn't footnote it, and perhaps he should have, by saying that, of course, in both scenarios, the planet is trashed for tens of millennia.
Thank you.
Well, I do hope that Emily and anybody else who wishes to comment on that will do.
If I understood well, I would say that there is no resilience at all in both scenarios. Even in the first one, the first scenario, actually from a scientific point of view, there is no resilience. You will have automatically genetic and transgenerational damages. So there is no resilience at all. We created a technology which is far away from our traditional frame of reasoning from an ethical point of view, and also concerning the risk. The concept of risk is not valuable for nuclear. Even when you're talking about nuclear safety, this is a myth. There is no nuclear safety. If you widen the temporality of your analysis, there is no nuclear safety. We do not know what to do for our nuclear power plants. We do not know how to ensure this safety for dismantling our nuclear power plants. We do not know how to ensure this safety for nuclear waste. We do not know how to ensure the safety for our nuclear weapons in the long run. So we have also to emphasize on the fact that there is no resilience at all when you talk about nuclear technologies.
Other question, please.
Hello, my name is Niwa Tinasu. I'm part of the student group from Germany, and first of all, I'd like to thank all the panelists for the very interesting lectures here on the matter. My questions are directed towards Madame Gaillard. You're an academic in law, and I'm certainly not. So my questions might be a bit superficial, but it regards the practical implementation of these basic principles of transgenerational human rights. Transgenerational law, thank you. You referred to. First, how can awareness about the issue be raised in the large population of the world? Because right now we're living in the context of a global spanning economic capitalistic system, which is focused on short-term gains and usually doesn't take the implications of actions to future generations in consideration. So how can the issue actually be raised? And the other question is, how would the practical implementation of these principles look like? Since there are many democratic countries in the world, how can somebody legally represent respectively, articulate the interests of future generations? Thank you.
So I will start with the first question to answer to you. What I'm pleading is part of a scientific revolution. We have to change a paradigm in all sciences, even and more in economics. So I would quote a professor who said that the one who thinks that we can pursue infinite growth in a finite world is either a mad person, either an economist. So I think that is the point. We have to change the major paradigm in economics because there is no sustainability at all. So I'm just repeating what also was described, written in the Meadows report. So I would say that it's a huge change of paradigm. So this is for the first question. For the second one, you ask, can you ask again?
Yeah, of course. It was about the practical implementation, because how can you legally represent or
future generations?
Exactly.
Yes. Well, there are various paths. So this is a part of my thesis. But I was, for instance, last week with Tony Oposa, who's an attorney, a strong leader in defending the environment. He is at the origin of the very, very first case law on future generations. For instance, in 1993, he pleaded in front of the Supreme Court of the Philippines on behalf of future generations, stop this massive deforestation, because if you authorize and if you go like that, in the next 20 years, there won't be any forest anymore in the Philippines. And he won the case. So I was with this judge, and I was also with him taking legal actions on behalf of future generations. So we are now facing that this is a new reality. You can find this on human rights for present and future generations, or even indirectly through, for instance, if you ask for the recognition of the defense of rights of nature, which is more close to other countries from South America, and more, we have to be respectful to that there is a legal pluralism. So this is different point of entry. You can, to be short, you can defend future generations directly or indirectly. You can manage to, for instance, in Brazil, you have a legal actions, I would say in French, in defense of intérêt diffus. Intérêt diffus means you, the civil people, you can ask for the defense of an general interest. So you can have technical mechanism, and I would plead for a recognition of these human rights of future generations and at the international level. For instance, there is a project that Professor Michel Prieur has deposited here, which is a project of the recognition of a third covenant of human rights, open to the idea of recognition of rights for future generations. So we have already today in positive law different ways, but we need also to enrich our legal frame in order to make room and space, because it's a change of paradigm.
Alan, can I just ask you one question, Emily? You teach among different in the field of jurisprudence. You teach human rights law in two institutions in Normandy. Can you give us an assessment? What's the situation in France as a general country? Is this done in many universities, or is your university specialized in that, or is it a general thing to do among lawyers nowadays?
Actually, when I was doing my thesis, I was alone in France to talk about future generations.
That was when?
But in 2008.
Okay.
But now that there has been more and more, climate change litigation, and that now we have some case law, I have colleagues who are working a lot more and more on this topic, so it's growing. But anyway, in our constitution, we have a charter for the environment, which recognizes also the concept of sustainable development. So the very concept of future generations is now inscribed in our constitution. So I work with an attorney, and I'm going to ask our constitutional court what is called a priority question of constitutionality, question prioritaire de constitutionnalité, on this. So we have to ask our Supreme Court. So this is occurring.
Thank you. Alan also wants to make a comment on this last question.
Yeah, thank you very much. That's a very important question. How can these principles of protection of future generations be enacted? And Emily's mentioned a few, I'll mention a few more. One of my other organisations, World Future Council, has been picking up this particular issue to advance protection of future generations. And so we'll be monitoring some of the different ways of doing it. One is through having a commissioner or advocate for future generations, either at a national level or a regional level or an international level. There are already some in existence at national levels. Hungary, New Zealand have them, for example. And New Zealand is tied in with the Parliamentary Commissioner for the Environment, but includes protection of future generations in the basis for that. There is a proposal to establish a guardian for future generations through the European Parliament, for example, and that's getting some traction at the moment. There's also been a proposal to establish a United Nations, a guardian for future generations, and the former Secretary General Ban Ki-moon was quite supportive of this and spoke about this, I think, at one of the climate summits. So that's one, having a guardian or guardianship process that's adopted at levels that has some authority to ensure that legislation is developed in order to protect future generations. Another is to advance it through courts, through court cases, and we already have some court cases that have advanced protection of future generations, including a Dutch case on climate change, requiring the Netherlands government to take further action on prevention of climate change, and in that case it cited protection of future generations as one of the reasons. There's a case in the United States courts at the moment which is also using the principle of protection of future generations to challenge the US government to do more on climate change. So court cases is another way of enacting it. Also, to bring it into political and legal documents. So, the fact that the protection of future generations is in preamble paragraph 4 of the Treaty on the Prohibition of Nuclear Weapons, for example, is very important. And the more that it's brought in to political and legal documents, is very helpful. And then there's also at academic or civil society level, raising it in various mock court cases, for example. Now you're doing a mock United Nations negotiations at the moment on European nuclear weapon-free zone. Maybe you can bring into that protection of future generations as one of the key reasons for establishing a European nuclear weapon-free zone.
Sure, they would do.
I was involved in a case on ecocide that was held in the London Supreme Court, and that was a mock case on two aspects of ecocide, challenging corporate practice, and ecocide had this part of protection of the environment for future generations. And so they were like public expressions and demonstrations of this. And finally, World Future Council has been working on a draft code of crimes against future generations in order to enunciate what this might be. Now, it's just a draft code, but we know that the statute for the International Criminal Court started similarly in civil society with a draft code of crimes that then got moved into the Rome Statute with negotiations. So if you develop from civil society some of these draft treaties and mechanisms, that can then provide the way then for political process to get them adopted. And there's already a process process for getting ecocide adopted as the is it primary of humanity through the UNGO General Assembly process? Thank you.
Okay, Andy, you raised your hand.
Yes, I suppose this is a question for Professor Kayar. And extending on a previous question to some degree, the logic of this position is that a economic system whose dynamic is the endless competition among very large organizations for material accumulation is illegal. That essentially capitalism is illegal. So, given that, I was wondering what kinds of thoughts you've had about developing justiciable standards that would allow some set of distinctions to be made within this broader set of concepts, since a favorite way of courts, at least in my country, of avoiding decisions is to say there aren't any.
Well, it's a difficult question. Thank you for asking it. Well, actually, I think we are now at the limit of the capitalism theory and ideology. When you look about the pollution of the ocean by plastics, when you look about all the things we are disturbing here on Earth, on the basic equilibrium, we have to renew our friend in economics. I would quote, I think, one of the best, I think, more valuable principle that has been proposed by Professor Michel Puyer, who is a professor whom I really like and appreciate to work with. He proposed a principle of non-regression. That is to say, now we have to recognize that we have worked for decades in order to defend the environment, and we have to protect what we have already gained. So this principle of non-regression has to be now to be flourished, and we are working about inventing indicators of this principle of non-regression. And one of these indicators shall be also an economic indicator. So this will be a pluridisciplinary research we're going to do next year, not the next week, but next year and for years. This can be a very valuable principle. Another legal principle would be the precautionary principle. For those who are against it, I always recall them that already we have the system of pharmacovigilance. Do you say the same in English? Pharmacovigilance for medicines. You have a system that you are always making a report, and you have to react if you discover new effects or secondary effects of medicines. Precautionary principle is like that. It's a dynamic principle. It's a dynamic principle that means that once you have evolution in the scientific fields, if you have new scientific knowledge about more risk or not, then you have to evolve and evaluate on the consequences from a legal point of view. So either you strengthen the prohibitions, or either you can say, okay, there is no risk of disaster, so we can authorize. So these are two strong legal principles.
Thank you. There is a question back there.
Thank you. This question might be addressed to all of you, but I just try to lower it right now. I can imagine that especially human rights are a tough topic to deal with, especially at the United Nations level. See how much can be reached in disarmament issues like nowadays. It's a slow process. But suggestion for a first step towards maybe to making human rights more effective. I think so far the only subjects of human rights can be sued are states, if I'm not wrong. It might not be good to privatize human rights then in a way that corporations are part of it, or even NGOs as well, so that they could sue states or whatever. And the other thing is, if future transgenerational human rights are implemented and NGOs would part of this process as well. Could they sue nuclear weapon states that they don't stick to human rights? I'm not quite sure how, and which institution could do such a thing. It's pretty far out.
I participate to another kind of group called I was in the organizing committee of the International Tribunal against Monsanto. In the advisory opinion, at the very end, the judges emphasized on the fact that we should strengthen the responsibility of corporations and multinationals. And this is definitely a point that has to be discussed, because if we do not strengthen the defense of our human rights that are being infringed by multinational, then you're going to reduce the frame of human rights. So this is a very important point. And for the second part of your question, I did not note, sorry, but definitely I think that civil society, but Daniel has recalled it here already. As civil society, you can ask the Human Rights Council some questions such as this one. So the pact I was quoting, the third pact project that Professor Pryor has proposed is inscribed here, and civil society can call and support it. So there are various ways, and we have to invent. Anyway, to just the fact that you're saying transgenerational human rights, I have reached one of my goals as an academic.
Thank you. This question here.
May I'm Von der Wiesen. I'm an attorney in Amsterdam and also vice president of ILAN, one of the vice presidents. I lost count how many we have. And I have a bit of a problem with the concept of future generations having a right. In my view, but that has been formed ages ago, so maybe it's time to revisit that. But rights are always connected to a person, a natural person or a legal person. And I don't see future generations having legal personality, let alone personal personality. So I find it difficult. Also, because rightly the question was raised, who is going to represent future generations? And, basically everybody is entitled to do that, or nobody is. And obviously, there is a right to life movement, which is focusing on unborn life, and it claims to be speaking on behalf of unborn life, and it claims to, and also justifies horrible acts in defense of unborn life. So I find it difficult to approach it from a rights perspective. I think that the other side of the coin is, in all human rights discussions, obviously is the duty to protect, and the duty to respect, the duty to enforce the right to life. And I think that one of the important findings of the Rio Declaration, the important confirmation given in the Rio Declaration, I think it's part 14, 13, it's the one on sustainability, just formulates the principle that we all have a responsibility for mankind in a way that also future generations are able to be part of mankind. And that is, to me, a very important statement, principle. And it's also, from a legal perspective, I think, much more attractive, which includes, as Tony from the Philippines has done, he has approached the issue from a responsibility point of view, and a case against the state who was neglecting its responsibilities towards mankind, which obviously includes future generations, because we all think, until we stop thinking that, but we all think that it is not up to us to close the door after our generation. It is not up to us to use the planet until nothing is left of it. That is the thinking, I think, behind the responsibility that we have towards mankind. So I'm not at all opposed to help stress our point and to explain how far our responsibility and the responsibilities of the states are to be defined, to include responsibilities towards future generations, but it's a norm of our own civilization rather than a right of future civilization, I would think.
As a simple doctor, I feel more compelled to do something if I know somebody has the right of the future generation, than if I say it is my responsibility to do something, because responsibility is a fluid term, whereas a right, to me as a doctor, I feel I'm much more compelled to do something. So in order to sell what we should do for future generation, I think I accept it I recognize this need to respect the rights of future generation. But that's just me as a simple doctor. And Daniel?
But just briefly, when I say responsibility of states, then we're talking about a duty for states to do so, which duty is violated almost by every state in the world at this very point, because there is no single state who fully accepts and enforces its own responsibility towards mankind in a way that it includes future generations. And, selling it on the basis of something which, from a legal perspective, has its difficulties, using the concept of right, if that has serious difficulties, undermines your selling power, also as a doctor.
Okay, thank you. Daniel first, and then Emil.
Like my colleague Brand Paul, I'm litigating cases. I'm basically at the court of human rights. I'm confronted with actual, current, realized violations of human rights. And it's true that we are only lawyers, and we have a tendency to see something we can't litigate easily before a court as not being law, basically. And it's difficult for me as well to see the added value of the concept of future generations from that point of view. But it is probably attractive supplement, like to more like a moral principle which can give more input to a legal litigation, moral, philosophical ground. I tend to agree with Fon to say that we have so many, and I try to say that and to explain it in my speech in the end, we have so many fantastic human rights bodies and instruments which are addressing actual violations, real violations, real problems of human rights, but which can be used and which of course will serve the future generations well. If you talk about rights of children, a healthy child will grow up healthy, will give a new healthy generation. A child which suffered from nuclear testing in Zemapalatinsk or elsewhere, it is different story. So I think if you respect the actual rights, or let's say the rights of actual victims, we contribute automatically to the rights of future generations. The same thing for the right to life, unborn life. Of course, future prospect, right of women, healthy women. We will give birth to hopefully a healthy child, which will be a future generation. So I think there can be a lot can be done on what we have already. We have so many human rights instruments which has to be addressed and which take into consideration of course as well future generations. But I think we have already a lot. Just a question which was, and then I stop, which was said before, privatization of human rights enterprises can be held responsible. This is already something which is very set in jurisprudence of human rights courts. There are, of course, as Fon said, there is an obligation to protect of the state, to protect also against acts of private actors, against enterprises. We had recently a case in Strasbourg with human rights where somebody sued its employer for having been controlled in his private email writings during the day. He was sacked because of having used private email during the day, and the European Court of Human Rights found a violation of privacy. So there is actually these days no issue about privatization of human rights. It has already been done. There's obligation to protect. There's a positive obligation to protect of the states, even against acts of private enterprises. Anybody want to add?
So I have answered to all your questions in my thesis, which is written in French, but to be short, I explained the first path from theoretical point of view concerning the theory of subjective flow. At the very beginning of the 19th century, we have an author who said that there is no problem to recognize rights of future generations, because he was thinking the theory of subject of flow in a complex way. That is to say, you can have a subject of right who has the right to enjoy a right, and another subject of right who has the purpose to implement this right. So with this logic, it's possible to make some room to defend future generations, such as Tony has done in the Philippines, such as it's already now occurring with nature rights. You know, the case law concerning rights of nature. It's exactly the same theory, but with nature. So we can add some complexity in the theory of subjective law. What you said, it has been already said when the UNESCO wanted to sign a declaration of human rights for future generations. And actually, this is the very point where there is a need for a change of paradigm, because if we do not change of paradigm, then that is what happened at the UNESCO. Finally, we have chosen a declaration of responsibility of present generations toward future generations. We didn't manage to recognize that declaration of rights for future generations. This is another project I'm involved in. It is a project of declaration of rights of humankind, because we need to renew our legal frame. And last but not least, Maybe the question of an ombudsman for future generations is definitely necessary in order to get out of our legal frame and political frame, which are enclosed in short-termism. These would be my short answers.
Okay, Alan wants to add a word.
Thank you very much. I'm not an expert on human rights. I think Fon's probably much more an expert than me. But a couple of reflections just to think about. One is human rights as individual rights versus collective rights. And I think you're probably quite correct. Primarily, human rights are looked on as individual rights. But there are also some areas where collective rights are entertained. One of those, for example, is the Declaration of the Rights of Indigenous Peoples, which has been adopted, and that affirms rights as a collective right. We can imagine the same with rights of future generations as like a collective right in a similar sort of aim. The other issue was duty to protect versus, the rights, and I had a similar sort of initial response as Andy, but just a little bit more to add to that. When you have a duty to protect, particularly if it's like a government duty to protect, the general approach to this by governments is to weigh that up against all the other duties that they have. And so if it's one that they don't have a huge constituency putting behind, it's easily put to the back. So the duty to protect future generations, for example, unless there is very strong, like an ombudsperson for future generations, or a future generations commission or something like that, it's just going to be put to the side. Whereas if you bring in the concept of rights of future generations, it's more of, there is more of, as Andy mentioned, some impetus that I have something more to do, but it's also that there's a slightly greater emphasis on the negative obligation, on ensuring that there are not actions that will violate those rights, whereas duty to protect is more on a positive obligation. And negative obligations are often a bit easier to identify. It's often easier to identify what you can't do.
Stop. No more questions. So yes. Sorry, I forgot you. I didn't forget you.
Yeah, Jonathan Frakes, World Council of Churches and Pax Christi International. It's a big question, so I'll just put it out there. It strikes me that environment and the integrity of people in the current moment are the two vectors by which we ruin the future. And both of these are quite a bit of them related. The misdeeds are related to economic things, especially in the environmental side. And so are there mechanisms at WTO, for example, or some totally different sphere where corporations are, like with cyber now and the handling of data, they're having to become more and more responsible for their impact on our world. And this may be a more imminent sphere of action than the kind of thing which lawyers and angels can dance on the head of the pin around for several thousand years, whether we're looking at future people's rights. It just strikes me is there some potential to take the approach towards your impact on the environment, because that's how you change the future, and your impact on the integrity of the human person living today, vis-a-vis transhumanism and the various things that we're hearing about.
Thanks for these thoughts, and with this I conclude. Thank you, Jonathan, and thanks for being here, and if you have questions, you can approach the speakers individually. Thank you very much.
Other people are